Hello everyone, welcome to Redbus US channel. In this video, we look at the new H1B visa rules that will be effective in 2025. This is as part of the H1B modernization final rule that DHS published yesterday. So what we will cover in this video are, these areas. We look at the background and we look at what are the various sections in it. And we look at first what are the things that are changing that are actually new, and then next we look at what are the things that are they are codifying. Basically, they exist today; they're just making them official, right? And then the effective date and what we can expect once Trump administration takes the office. So this is the official final rule that was published in Federal Register. As you can see, it was published in 12/18. So we'll actually have a link to the article in the description as well. You can get to this by reading the article as well. So first, just the background, right? I mean, just a quick background, right? So, this concept of modernizing H1B program has been an agenda item for Biden administration since 2021 of June, right? And it was there for the next regulatory agendas. And then eventually they published a proposed rule where they basically gave what are the things they want to change and modernize in October 2023. And finally, after that was published, due to shortage of time, they just did publish one final rule that was for changing the lottery process, where you select the applicant based on the passport number and all of that, right? So this was published in Feb, and that was actually applicable for FY25 when that happened earlier this year, right? So the rest of the items that were part of the proposed rule are actually the ones that are now published as a final rule. So in general, there are three main areas, right, that are that they're trying to do with this modernization program. So one is they want to clarify what is part of the program, and they want to improve the efficiency. So they are giving a bunch of provisions that are mainly targeted towards efficiency of the program and clarifying requirements. So the second set of things they're trying to do is give more flexibilities and benefits, right, for both applicants as well as sponsors, right? So that's the second one. And the last one they're looking at is the strengthening of the H1B program, basically to make sure there is no fraud, and this for integrity of the program. So first, let's look at the new H1B rules, the changes, right, that it will have. So the first one they're doing is changing the definition of the specialty occupation. So they are just, it's a minor definition change. But if you look at it, they are just making it more stricter, that you can't have vague job descriptions. Let's say if an H1B job, and then you can't say, generally put in the H1B job description, looking for a 4-year degree or a 4-year MBA degree, and then categorize that as a specialized, job or H1B job. So they're telling that, let's say you want to have a job in, let's say computer engineer, then, you should have a degree in computer science. So this would be something more specialized. So that's what they're trying to do. You can have multiple range of degrees as part of that. So that's why they really want to emphasize that it's a specialty knowledge is required, and education that you mentioned in the job description matches with the degree that the applicant has. So this is one big change they're doing. The second one they're doing is more on the F1 student, right? So F1 students currently, they get something called a cap gap. A cap gap is when you can work from the day you apply until you get a decision from uscis until October 1st or September 30th, right? So you can work. So the challenge with this was essentially, right, the cap gap would expire on September 30th. So let's say you applied in June and you don't get a decision, then you are basically like stuck, right? You can't work. So so you basically lose job and all of these complexities and employees business issues, with business continuity and all of that. So what they've done is based on feedback. So they're extending it from until October 1st to April of the next fiscal year. So meaning if you applied in June, let's say you got picked in lottery and your company applied in June, then you can continue to work on cap gap until you get a decision, or until April 1st. Let's say you get the decision in December, you can continue to work until then. So this is actually a very, very good one. There are some provisions that you have to timely file, and it has to be real petition, all of that. But the idea is it's going to really help all the F1 students who are actually in the US working on cap gap. The third important one is, this is especially for the entrepreneurs, right? Let's say you or controlling interest. Anybody who owns a company more than 50% has controlling interest in that company. So due to historical reasons and legacy things, right, employer relationship, all of these things, there were a lot of confusions on this, right? And many people would not apply, and they were not getting rejection. They were getting rejections and all sorts of things. And the idea was if you can't fire yourself, then how can you basically control and all of that? So all of that has been removed in the past. So eventually what they're making sure that right now is, you as a founder, even if you have more than 50% of the company as a controlling interest, so you are allowed to do non H1B or specialized related tasks. Meaning that, let's say you want to do payroll, all of these, talking to customers, all of these are not really specialized. What they want to ensure is majority of the time, which means, let's say 51% of the time at least, right? Or more than 50% of the time, you should focus on, let's say, the specialty occupation. Rest of them you can do all business related tasks. So this is really going to open up a lot of opportunities for entrepreneurs who are going to basically have ideas that they can build their own companies, and even be getting H1B sponsored by the same company, and also run the business. So this is actually a very, very big deal for entrepreneurs. So the next one is more on the inspections and FDNS site visit, right? So in the past, FDNS site visits, essentially FDNS site visit is where somebody from the government would visit and verify that if a person is there in the location or not. So this program is completely voluntary. There was no obligation, or you could as a you could have chose to say, I would not participate in this. Now for integrity and all of these reasons, they're making this mandatory to avoid fraud. Essentially now the companies cannot deny, they have to cooperate, they have to give all the details, including the clients. So if they are not able to verify any of these details and there is no cooperation, they may deny or revoke the H1B petition. So this is actually a huge change, and we'll have to see how employers and the companies will actually cope with this new change. The other one is more on the expired. This is another one, right? Let's say you submit documents and they get expired before they come to your case. Then what do you do with it, right? And you requested, dates for approval. No, they are passed now. So in these kind of scenarios, they were basically not able to handle it, and they're rejecting, or they're giving outdated dates. Right now, you have an option to, they will issue an RFE to give new dates of employment if they think that they can approve it, and then you can submit it. If nothing happens, then they will give for the old one, right? The other one is, cap exemption flexibility, right? So if you are not directly employed by universities or research organization, you can still be counted as a cap exempt if you work, majority of the time, at least half of the time, right? More than 50% of the time for any of these organizations, research organizations or universities that are cap exempt. Then you can apply as cap exempt H1B, meaning you don't have to go through lottery and all sorts of things. But the idea behind this is, rest of the 49% of them, you can work for anything else, and you can work for let's say you're a doctor, you have another private entity that you want to work with, and then you also want to be part of a cap exempt thing, then you could do this 51% of them, rest of them you can do. So this is actually a good one as well. Another one is Trump. When Trump first term was there, they removed this something called deference, means respect the previous decision given by the the previous officer if nothing has changed. It's usually for extra renewals. When you're renewing an H1B petition, they would give weightage or value or respect for the previous if nothing has changed. So this was removed by Trump. So they had to really review everything and educate as the first one. Now they are adding it back so that there is it'll save time and it'll be better for them. So this is until now what we discussed were the new things. So what they're also doing is existing program practices, either through lawsuits or whatever that are currently already in practice, they're codifying, meaning they are making it official so that it's part of the regulation. So amendments, right, when to file amendments and all of that. So this has been there for many years. So this is now codified, and they always were asking maintenance of status documents. Let's say you are in the country, you have to submit all these legal status documents. So this was always there. It's just they're making it more I would say legal by putting it in the regulation, and they also removed the itinerary requirements. You don't have to submit day by day what's happening on all of that. This was actually introduced during Trump. They're removing that as this came out of a lawsuit, right? Another one is you can't have any you should have real bona fide offers, right? You can't have something that is not valid, or just you create for the sake of the lottery and all of that, right? So they you need to if they ask for evidence, you should provide all of them. So this is all now codified, right? and they're removing employer-employer relationship things they're doing, and also when you should file H1B LCAs, and how they will be adjudicated based on SOC code, wage levels. So all of these are existing ones. They're just making them official, right? Let's put it that way. And the other one is third-party placements, right? They want to ensure that the work done at a third party is also specialty in nature. They cannot just take somebody and do some random work, So there's also some of this was practice, but they're codifying it, on paper. So another one is effective date, right? So this will be effective starting from Jan 17th, before Trump takes office, which is a good thing, for all the employer, all these, companies, right, who are trying to look at this, right? And they're also releasing a new form, companies have to use this new form. That's what they will have to do starting from January 17th. So now the big question is, can Trump really do anything right away? So when Trump administration comes, they actually take office on Jan 20th. So they really have to go through the whole regulatory process. It cannot be done like last time, where they would just take some of these away and all. It cannot. They have to go through this process. It can take a long time, right? If they really have to remove some or add any changes. Yeah. So if you look at historically, they have been very hard on H1B program. A lot of stricter norms. All of these things came in. So we'll have to wait and see. It's too early for us to basically see if there's a priority and they'll act immediately. So they have bigger issues like inflation, border issues, tariffs, all of these things that they're looking at. So it's very hard for us to know at this point. We'll have to wait and see. We'll keep you posted on how things happen, right? So thank you again for watching. Do subscribe for getting regular updates.